Without further ado, we'll get started. So you're all very welcome to this practice support information session. And today we're going to be talking about applying for appointment as Senior Counsel. And I'm joined today by Helen, Sheehy, Senior Counsel, and Bill Holohan, who are going to set out what's involved in this process. So you're both very welcome today. So I'll just introduce each of our speakers today. Helen Sheehy, who is from Cork and was educated at Mount Mercy School and got a BCL from UCC and an LLM from UCD. She qualified as solicitor in 1995 and as a sole practitioner with offices in Dún Laoghaire, and she's an expert in copyright law, particularly as it relates to recorded music and collective management organisations. She's a past president of the Dublin Solicitors Bar Association and a trustee on the DSBA Bursary Trust. Bill Holohan also is from Cork, and he's a UCC graduate and is a regular contributor to the small practice support sessions. Bill is a member of the Council of the Law Society and is the chair of the PII committee and is a member of the Alternative Dispute Resolution Committee and the Law Society's Curriculum Development Unit. One of Bill's claims to fame, having written 8 books, is that he once argued a case by himself in the Supreme Court regarding whether a seat in a theatre or in a place of public entertainment in law in Ireland is not something you sit on. So that's an interesting fact. So you're all very welcome today. So we'll get started. Helen, who should be thinking about applying for a senior counsel solicitor? Okay, well, the first thing is there are guidance. There's a guidance issued by the LSRA, and you need to read it very carefully. But the first thing that you have to be is a practicing solicitor, and there is a definition as regards that. So I won't go into the definition, but you need to have a look, because clearly you have to be a practicing, not just a solicitor. You have to have a tax clearance certificate, which is very important. And then there are 3 things that you have to satisfy, which are odd, I suppose. You know, firstly, professional experience, legal knowledge and probity, you have to have them. Professional independence and integrity, honesty and professional standing. They are very nebulous. I mean, clearly you'd imagine every solicitor would have these things, but you not only have to have them, you have to be able to describe the fact that you have them in 300 words or less in each case. So that in itself is difficult enough. But once you have those things, you can apply, no problem. And Bill, do you have anything to add on that about the types of people who should be applying? It doesn't seem like it's something for somebody who's just out of the Law Society.
No, I mean, you probably need 10 or 15 years under your belt to build up the track record and to be able to tick all the boxes, because you're not going to have to be a specialist overnight, unless perhaps you're a barrister who's converted, taken the suit and become a solicitor, or somebody who has a sterling record in academia and who's suddenly come out and picked up from their practicing cert again. Like over the weekend I was reading the biography of Lady Hale, formerly UK Supreme Court judge, and she spent nearly 20 years in academia before qualifying as a barrister, spent a very short time as a barrister and went on to become a Supreme Court judge. So it depends on what your background is and your expertise, your specialism, your knowledge.
And Helen, do you have to actually be a practicing solicitor to apply, or do you just need to have qualified as a solicitor? I think you have to have a practicing certificate. It says it in the rules. So if, like, for instance, you retired, you can. I mean, a retired solicitor can have a practicing certificate. So it does say you have to have one. Okay. And so over to you, Bill. Is there a particular area of law that's better suited or suits best for this process of applying?
No, I mean, there are specific categories, or boxes you have to tick in Section 173 of the 2015 Act, and you have to show a proven capacity for excellence in the practice of specialist litigation, and that's litigation, or specialist knowledge of an area of law. But, you know, Richard Hammond is trust and probates, Helen is copyright, I'd be kind of ADR, professional negligence. You know, there's different areas that people are into.
And Helen, would you have a view on this as well?
I think it does divide up. I think it's I think both of the areas of practice of specialist litigation and specialist knowledge of the law can go together. I think the advocacy, it might be regarded as a sort of like a slightly separate thing, because it seems to me that an advocate can advocate about anything. I mean, I do advocacy, but I do it only in my special area where I actually know what I'm absolutely sure what I'm talking about. So I think it is more likely that a solicitor will fit easier into the areas of a specialist litigation or specialist knowledge of the law.
So if I was getting started out now as a trainee, the whole idea of having a specialism would lend itself more to being an advocate and then applying for SC than someone who was just general practice. Is that an unfair summary?
I don't think they're looking for somebody in general practice. I don't think so.
Yeah, okay. And do you think it suits any particular type of lawyer in general? Or have we just answered that question? So do you need to be a partner in a firm before applying?
I don't think so. I think being a partner, the big firms will facilitate you becoming an expert. There's no doubt. They will teach you, and you'll be in a position to you know, as you move up the firm. I'm sure you get loads of experience. And the other reason why a big firm might have you is because they might headhunt you because you have your experience. So for those two reasons, that the likelihood is. And the fact is, an awful lot of people who apply are in big firms, but that doesn't need to be the case at all. And certainly I'm not in a big firm and never have been. But no, you definitely don't have to be, but I think it'll happen that a lot of people will be.
And obviously it's a particular area of law that you specialized in was what was of the how would you say, the defining factor?
It is the specialism, yes. And I didn't need to be in a big firm as it happened to become a specialist in my area.
And do you have any advice for people who are looking at specialisms at the moment as to what area you should specialize in?
Okay, my general advice is you should specialize, because I think it is really difficult to be a general practitioner. And a sole practitioner, general practitioner I think that must be hell on earth. When you consider all of the, you know, the regulatory problems that you have and the insurance problems and, you know, everything. So, yeah, I do think in general specialism is where it's at.
Another session for another day.
It is.
In terms of the future of the general practitioner. But I agree with Helen. You have to specialize really in order to tick the boxes for this. You know, if you were a general practitioner in the district court with a kind of a mixed bag, plus conveyancing, plus a bit of labour law, plus a bit, you don't have the necessary specialism, I'd say, to satisfy the committee.
I think you won't have the kind of almost brand awareness, because the people who see you in the district court, particularly if it's a local district court, are not the people who are actually making these decisions, you know. So you need to be litigating in a higher court in many respects in order to be seen.
And that's back to the point about advocacy as well. And that's where the barristers would have an advantage, because they've got the face time with the judges. So the exception would be that solicitors would argue. Now, I came originally from a bankruptcy insolvency background. Bankruptcy court was a solicitor's court rather than a barrister's court. Now, the barristers have kind of taken over in the past 20 years. And that's where I was quite used to arguing things in the High Court. And subsequently, as Justin mentioned in the intro, I persuaded 3 judges that the Supreme Court seat is not something you sit on. Different story for a different day, cup of coffee session. But it's difficult for the solicitors rather than the barristers to tick the advocacy box or the expertise in advocacy.
So here's one for you, Bill, and I'm going to wrap 2 of them together. How would I know I'm suitable to apply? And do you think someone recently qualified could apply?
Recently qualified, I think we've covered that one. It'd be very difficult to show unless you're kind of coming with some kind of life experiences before you are actually qualified, that you could show the expertise, the specialism. You know, if you were an expert in competition law or something in academia, and you then joined a firm, took out your practicing cert, then you might be able to show you're able to tick all the boxes. So recently qualified, unlikely. And the second part of your question?
Well, I'm going to actually slightly change it. The criteria for applications, I think we should move on now into the more deeper questioning around. We kind of understand suitability now, but if I'm into making an application.
It's in the Act, and you need to look at section 173. It says, quote, has in his or her practice as legal practitioner displayed a degree of competence, probity appropriate to and consistent with the grant of him or her of a patent. And Helen's already mentioned, you know, what does that amount to? You know, probity, honesty, integrity. Do you think people would accept your undertaking if you offered it? Would they take a verbal undertaking from you if you offered it? If you can answer that question yourself to know, maybe you should be going for it. Independence, and then one of three things: proven capacity for excellence in advocacy, and that's where the barristers probably have the advantage. Proven capacity for excellence in practice of specialist litigation, and it's litigation, not specialist law. And the third one, specialist knowledge of an area of law. You have to be suitable character and temperament, tax clearance certificate, and quote, otherwise suitable. In other words, that you're not considered to be a proverbial B of one kind or another, that your reputation precedes you and they're likely to knock you back. But talk to colleagues, talk to people who have already applied, who've been successful. You could be underselling yourself or you could be overselling yourself. And probably your friends, family are the best people to tell you that.
And just a question there around professional independence. What is that? What's meant by that, Helen?
Well, I was lucky to be making this application in the middle of a lockdown, because I would be wandering around the pier in Dunleary, which is within my 2 kilometers, trying to figure out what on earth. Of course, I'm independent. How am I going to explain that I'm independent? These are the boxes that you have to fill in the areas of probity and professional independence and integrity and honesty are difficult, and there are 3 separate boxes, and so you have to come up with 3 different rationales for it, So I was thinking about that as to why I have professional independence, and in my case, it's going to be different for everybody. I decided I landed on the fact that I did take 2 solicitor negligence cases, very big cases. Both of them lasted for many, many years. And I was just pointing to the fact that I thought it was right that people who had cases against solicitors should get good legal representation. I also thought that it was right that people who are being sued, should be treated with decency, and it shouldn't be, used as a, it should simply be taken in the normal course and done decently. So I just spoke about that for a bit, and I filled up my 300 words like that. And as regards the 300 words, let me tell you, because I've done so many legal submissions, after a while, how to make something exactly 300 words. And I do think it's probably very important that you don't overstep the number of words, or, you should get, I actually anally got exactly the right number of words in each box.
And that takes time, Justin. This is not something you decide, the closing date is Friday of next week, I think I'll have a go and throw in an application. I spent a cumulative of nearly 3 weeks working full time, spread out over quite a period of time preparing this.
Equally, I did too. And as I say, if it hadn't been locked down, I would not have managed. I wouldn't have.
And so I've gone through this process of filling out the application form. So then how is it decided? Bill?
Well, there's a committee, and the committee again is set out in the Act. It's the Chief Justice, it's the President of the Court of Appeal, it's the President of the High Court, the Attorney General, the Chair of the Bar Council, the President of the Law Society, and Don Thornhill, who's a lay member of the authority. So you can see immediately when it comes to barristers and face time and court exposure, Chief Justice, Court of Appeal, High Court, Attorney General, Chair of the Bar Council, they would have brand recognition. It's difficult for solicitors, particularly those who don't practice in court, as in specialist litigation, but with a specialist advisor. So, hats off to the Helens of this world who wouldn't necessarily be routinely in court, but who were able to demonstrate their.
No, I had a long line of cases that were reported, so I was able to, and some of the judges had been, judges on these cases. So I think the brand recognition did come from specialist litigation, even though I would have said that I went under it was a specialist area of law, but there was also specialist litigation. And once you have you have to put in your reported cases. So there was a list that if you didn't have that, I think yes, you would have a problem. Yeah.
So I've just added just to the chat there for people, just some of the links to the LSRA and all of the documents that we've kind of just been discussing. And if anybody would like to ask us a question, we'll take it on the chat. So Bill, do you have anything like presumably you can't advocate outside of this? Like you put in your application form. There's no point going talking to people and who you know and that side of things.
No,
Is
the
major no.
things about canvassing will disqualify you.
Yeah.
And it's likely to work against you if you were to try it.
I would say so, yeah.
So then just Helen, moving on to we were looking at the numbers a little bit around gender balance. Do you want me to pull up the numbers for you?
Sure, you can do that, yeah.
Yeah. Just to give everybody a flavor. Oh, that's not, may not be this. I'll just, 1 second, right? So there's the numbers of patents and credence applications from the LSRA.
Now, I suppose I was looking at that and I was trying to say, well, okay, what does that tell us? Well, what it tells us is that there are more male applicants than female applicants. Certainly in the very first year, it was like 80%, 80 to 20% were male applicants. And I was thinking about that, and I think that probably it's not unreasonable when you consider that for the most part, you'd have to, be around for quite a number of years in order to get the level of competence to be able to make the application. So I suspect there is probably a bigger pool of male solicitors. So it's probably not surprising that there are more male applicants than female applicants, although it does, for the second and third year, it's closer. It's like more like 1 in 3 as opposed to 1 in 4. And in terms of success rates, there doesn't seem to be like, certainly as you see, like in the grants in the third set of grants in June of this year, there were more females granted than males, sort of 57 to 15%, which is quite a lot. So anyway, it seems that there are more applicants, but it doesn't necessarily follow that there are that more male are getting, as a percentage, are getting through. It seems to be more like the quality of the applicant that would determine it rather than the sex, if it weren't for the fact that more males apply.
And Bill, do you have anything to add on the numbers at all?
No, I finally got them last night from Brian Darton in the SRA. There's a thesis that could be written about that, as to why the numbers are the way they are. But as they say about 2,000 years of Christianity, it's too early to tell.
But one thing that is actually interesting is the failure rate. The failure rate in the first year was 64%, the second year was 88%, and the third year was 70%. So, getting through, like it's not easy to get through. That's the truth of it.
And so just moving on to the next question, just around the actual application form, Helen, and getting into a little bit more detail around that. Is there any areas within that? Like, so we start off with personal details, which is there anything in there that could trip you up? It seems fairly obvious.
Well, all the first section, part A, is all with the personal details, your academic and your professional qualifications, your career history, and your experience and your reported cases. They also ask you questions about like cases that you were involved with, that you thought you brought what you brought to the table. These require you to dig deep, and also, as I say, not to be shy. You really cannot hide, your light under a bushel, because in any case, as everybody knows, in a team, there will be an awful lot of people, and so they're asking you what did you do that made the difference in, for instance, like you might have 2 seniors, 2 juniors, and and yourself, and like, what was it that you brought to the party? So, as I say, there's a lot of time needed to reply to those questions. Now, if you're going under specialism, there is an opportunity to show your published works. So you may have articles published, or you might have, well, obviously, if you've written a book, that's very straightforward. Or you may have given lectures, and there's a limit to the number. They tell you how many, and you fill in, and you have to send PDFs or links to those. So I'm presuming when they get them, they check them to make sure that you generally are what you say you are. And just one little thing that I couldn't, I mean, part of the reason, as I moved along, I did start off and I wrote a lot of articles, you know, way back in the day, long time ago. And they weren't online and I wasn't able to find them. But just a trick, the Law Society Library is wonderful. The Law Society Library has hard copies of an awful lot of the old digests that so I was able to find all my old articles in the Law Society in hard copy and just put them on PDF and send them in. That's just a little hint for anybody. What you have to put in, oh yes, and this is another thing that happened to me. You get the application form, you fill it in, you have a declaration at the back, and then you presumably have your own file in the office, and then you're putting together all the things that you need to go in, and and then eventually, because it was COVID, and I think it's still the fact, you put everything in electronically. Put everything in time, and then Ulton, who's the guy who's at the other end, rang me and he said, you never sent in your application form. I had every single thing that was on the list in the application form, but no application form. So I thought he had a heart attack, sent it in, and then Ulton wrote back and he said, and now breathe. So they're, you know, they do help you. They're quite kind at the other end. So and you need a headshot as well. I don't think I saw that anywhere else, but of course, in the middle of COVID, you basically take it off your, you know, it's pretty much a selfie you had to send in. And then of course, maybe somebody else will deal with the references, but you need a reference from a judge at any level, and it can be a retired judge and a practicing solicitor, or I could even be a practicing barrister actually.
So two questions, Helen. Well, one is, I don't know a judge. Does that say it all then? Yeah.
Maybe it does say it all, you know, to some extent you're going to have to know somebody. I don't think I can tell you how to do this if you don't know a judge.
Yeah.
And that goes back to the kind of the age and the seniority bit as well, because, you know, as you get older, people become judges. So someone you were in college with, or someone you did a case with, or whatever, you know, the likelihood that you wouldn't have some connection to a judge is pretty remote, the older you get.
Yeah. And, you know, it could be that the judge is somebody that doesn't work in the area you work in, but he seems to be a friend. Well, give him your application. You don't have to give him all the, you know, but show him your application. He or she might be able to say, well, actually, I wouldn't do it like that. Or, but mostly they'll be able to use it to put facts next to the impression they have of you when they're writing their letter of reference.
And a lot of strength is based on that, particularly for solicitors who mightn't be known to the judicial hierarchy that I listed out earlier, because they'll be relying on the reference from someone that they know and trust. And that's where the actual wording of the reference becomes crucially important. You know, we hope that you'll think of Justin the same way we do after the years of dealing with him. You know, what does that mean? You know, so you need someone who will be in there pitching and saying, yes, this person deserves it, and for the following reasons.
Yes.
So it's not a two-liner reference. And again, they will be very choosy as to whether they actually give you a reference or not. They won't simply bang one out because you happen to have gone to college with them. They will think carefully about recommending it.
A friend of mine made an application in the last lot, and I do remember like that the judge met, no, they knew and they were working in the same area, but they still had a formal meeting and you know, went through what they were saying and all that sort of stuff. I was in a different position. I think my judge friend would have done that if it hadn't been for the fact that it was COVID and we were all locked down. So I think people are treating this quite formally, so they're not just writing off letters.
Yeah, so it's something that requires a bit of pre-planning. Would you mind commenting just on that section 8, character and temperament? What is meant by that?
Well, you wouldn't have a criminal, you know, they do say that.
But how would you demonstrate that in an application? And what is?
Well, well,
Is that they want to know more about your social life, or like who you like? Are you into sport or other achievements, or like writing books, or you need to?
they ask you in the form. The form actually covers all of those. And what the question is about temperament. Specialist knowledge, excellence. I don't think they say temperament. There's professional experience, legal knowledge and probity, professional independence and integrity, honesty and professional standing. So I don't think there's a section where you.
Okay, I was just reading here, section 8, character, temperament, and then section 9, referees. I'm not too sure where this is referenced off. That's not good. Too hung up on it. So do you have any other tips then? We're kind of coming to the end of the session now, and I was just wondering, like as a wrap up, like, do you want to give a brief summary and some tips as to what people should be thinking about in applying? Bill?
Plenty of time out. As I said, like, we spent weeks putting this thing together. And, you know, it might be that you're thinking about applying, but maybe applying 6 months to a year in advance. Because again, you know, Helen referenced the question of getting all the materials, articles you might have published. That can be quite difficult. Now, Maura McAnally did a session for the Irish Women Lawyers Association on all of this, and she said that she, as chair of the Bar Council, read the instructions and they had to read everything. And she referenced one particular applicant, was the way she put it, who is online, and that was actually me, who had submitted a copy of all publications. I didn't give them copies of my books, but I gave them copies of all articles, and it ran to over 1,200 pages. And I pity anybody who had to read 1,200 pages of rubbish for me. But they did do it, and that's how seriously they take it. So, you know, within 300 words, you've to become a Twitter-like expert in terms of accentuating the positive, depreciating the negative, and not missing the mister in between. And that takes an awful long time.
Do you think there's any disadvantage to applying and being rejected, or just applying to start the process?
It's confidential, so no one knows. Yeah. Unless you go out lowholding, oh, I've applied and I'm confidently expecting to get it, and then you don't, then it's a kick in the proverbials. But it's completely confidential, so no one outside of a very select group of people will know that you've actually applied. But
you think it's a disadvantage from that you've gone for a position and you haven't got it?
No, as Frank Sinatra said, high hopes that ram at the dam. Keep going if you think you're worthy. And again, do the reality check. Friends and family, ask them what they think.
It's Helen? A shame. I don't know. I don't know if people are told, you know, to apply again, or if they don't get it. I don't know.
There's a friend of mine who applied barrister on round 1 under the new regime, and he didn't get it and was disappointed. And he was told exactly why, and it related back to the application. Again, they felt that he hadn't demonstrated certain things in the application. Now, he said, in fact, he was delighted he didn't get it the first time round because of COVID, but that was a separate issue. But they gave very limited feedback, but they did give some feedback as to why.
So we're just coming up to the end of the session. Unless, Helen, you have some final words or anyone has a final question, I just wanted to point out that on the 28th of September, we've got an update from Michael O'Scahall from Crow around the up-and-coming budget. So I just wanted to let people know about that. And if anyone wants to get in contact with me, you can just contact me here at the Law Society. So without further ado, unless, Helen, would you like to sum up or give some final tips? Is this something people should go for? It seems like a very comprehensive process, but you need to be prepared. But
I think you need to be prepared to put an awful lot of time into it. And one of the things that I did find is my entire career written out there in front of me, and it can be quite a shocker, and it can make you feel old.
And Bill?
I didn't turn grey by completing the application form. I was grey before I did it.
So you suggest people should go for it. It's changed your lives. It's made a positive impact, and
I would say it's changed our lives. I mean, Richard Hammond from Mallow, I think, was interviewed in North Cork Radio and was asked, did it make much difference, or would it make much difference? And Richard Everett, the pragmatist, said something along the lines of, I don't think Mary Murphy from Duhallow would appreciate the extra naught on the bill because it's SC after the name. It's branding in one sense. I've noticed a difference in the sense that I'm now being asked to give more expert reports and opinions on professional negligence and this type of stuff than before. Now, is that because of SC, or is it because COVID is over? Don't know.
I just think it was the greatest honor ever.
Well, on that note, thanks very much, Helen and Bill, for sharing your experiences today. I know it's like a private subject matter, and but we really all benefit from just putting a little bit of a light on this subject matter to try and get more people to apply. We will be sending out a recording of this information session with some of the links later on the week on Friday. So listen, everybody, thanks for joining us today. We hope you join us on the 28th for good news in the budget, hopefully from government circles. So Sloan, August Gurma. Thanks, everyone. Talk to you soon.
Bye. Thank you.
Bye.